Alex here with a legal nuts and bolts video on withdrawal of motion. You can withdraw a motion. If you haven't watched my videos on motions, you won't have any clue what I'm talking about right now, so please watch that video. It's going to be a short video. I just want to let people know that there was a way to actually withdraw a motion. In Nevada, I can't recall now if it was a local rule or under the Rules of Civil Procedure. It's probably in both. And what I mean by that is the Nevada Rules of Civil Procedure, which encompasses the district, the whole state, all district courts under the state. We also have Justice Court Rules of Civil Procedure, which covers all of the justice courts in the whole state. Anyway, I don't want to get into that right now. The point I'm trying to make is that if you file a motion and you want to take it back, you can't. And you do so in Nevada by filing a notice of withdrawal of motion. Once you do that, your motion's withdrawn, and that's it. It should not be considered by the court. And if you're in a judicial district that requires you to file a request for submission, which I have a video on that. Go ahead and watch it if you want to know what that is, request for submissions. Anyway, if you're in one of those judicial districts, then it's even easier. After filing the notice of withdrawal, which you should still file, because if you don't file that, your opponent's not going to know that you're withdrawing it, and they may end up expending resources, time and money on opposing your motion needlessly. And that could come back to bite you. If you withdraw a motion, they may be able to come after you for sanctions, trying to say that you were just wasting their time. And I talk about how this works a little bit in my video, attorney fees and costs. And I also talk about how to defend against these sanctions, but that's not really relevant right now, so let me just move on. Anyway, make sure you do let your opponent know, even if you're in one of those judicial districts, because sometimes people just will say, well, I don't really want to proceed on this motion, so all I'm going to do is not file the request for submission, and then the judge will never see it and never rule on it. Well, that's true, but your opponent doesn't know that. They can't read your mind, so they may end up filing an opposition, wasting time, and then making a big stink out of it later on. I can guarantee you, if you're representing yourself and your opponent has an attorney, they will make a big stink about that, and they will try to say that you're just harassing them, wasting their time and money, and try to get attorney fee sanctions imposed on you, which are crippling. Of course, if you're not in a judicial district that uses a request for submission, you better file the notice of withdrawal, otherwise the judge is going to think that they have to rule on that motion. So I just want to let people know about that, because it actually does matter sometimes. I don't know if anyone knows about what a safe harbor provision is, but if anyone here wants to take a look at Rule 11 sanctions, the Federal Rules of Civil Procedure explain how you can get out of what's the phrase I want to use? If your opponent tries to threaten to impose sanctions on you for filing something without a reasonable basis, there is a safe harbor provision in the Federal Rules of Civil Procedure, Rule 11. Nevada Rules of Civil Procedure and the Justice Court Rules of Civil Procedure mirror that same exact safe harbor provision. All it is, what it is it allows you within a certain amount of time to withdraw your motion. And if you do so within that amount of time, you will not be exposed to sanctions. Of course, you should look into how this works in your state, because it might not be the same. And all I wanted to really do right now is give an example as to why somebody would want to withdraw a motion. I know a lot of people here who are in litigation against an opponent, especially these high conflict child custody cases, really aren't thinking about being nice to their opponent. So why would anyone want to withdraw anything? You know, most people here aren't thinking that. I did withdraw a motion at least once, maybe twice. Because I was really trying to be different. I didn't want to be the litigant who was just like all the other litigants, that was just on a warpath and just wanted revenge. And so there were a couple of situations where I filed a motion, my ex started to change her tune, and when she did, I withdrew the motion. And I was able to rely on that later on, because when my ex's attorney was trying to paint me as a vexatious litigant and harasser, I was able to say, well, if that's true, why did I withdraw those other two motions? Why wouldn't I make you file responses to those? So, I mean, you can use that. Don't withdraw something just to be nice, just for the sake of it. Withdraw it because it actually is no longer relevant, because you actually feel you no longer need for that to be addressed. I talk about why you should not just do things out of the goodness of your heart in my video, How Abusers Win, in case you want to get into the details of that. But I think at this point, I'm going to go ahead and end this video. I just wanted people to know that there was a way to withdraw motions, and I've kind of done that now. So go ahead and I'll see you guys next time.